got 2 minutes.
Yeah, thanks, Chair. I mean, Minister, the measures that you outlined that young people have already are obviously welcome, and I don't object to them. I broadly welcome this bill, but what we're trying to do here is make it better. And I again come back to the point that we are not outlawing the issue of a young person being remanded in custody. We're trying to ensure a situation where the state is forced to act and the onus is on the state to expedite that trial. If some young person is accused of a very serious crime, the Minister says, well, the guards might have to have time to get the evidence. Well, if that young person's liberty has been taken and they've already been brought before the courts and charged, I should presumably hope that the guards had already got a significant body of evidence. And all this is saying is bring the person to trial, and by all means, if the court decides that their liberty needs to be taken and they do need to be detained, do it. But I mean, Recommendation 20 of the Council of Europe 2003 recommends that young people should be remanded in custody for no longer than 6 months before the commencement of their trial. As I said, this happens in England, in Spain, in Portugal. It's 3 months. So there's nothing bizarre or outlandish or revolutionary about what's been done here, and it is very much in compliance with the idea of expediting trials, which we should be striving for. And the Minister says everybody has a right to an expeditious trial. They do, but it doesn't always happen. And making it unlawful to detain a young person on remand for longer than 3 months and specifying that in law, to my mind, will help, because those cases should be processed faster because of the age of the young person.